Thank you, Mr. Chairman. Thank you to our witnesses for being here with us today to talk about this important issue. Mr. Miscamara, every member of Congress is elected by secret ballot. House Democrats elect their own caucus leadership by secret ballot, and Democrats held up the USMCA trade deal to guarantee that workers in Mexico have the right to a secret ballot. But apparently Democrats do not think that is the right that should be afforded to American workers. The Democrats' PRO Act and the NLRB General Counsel are working to overturn the precedent that protects a workers' right to decide union representation by secret ballot vote. If a union fails to gain enough votes in an initial secret ballot election, the PRO Act would make it easier for unions to organize by disputing the election results and claiming the employer wrongfully interfered. My bill, the Employee Rights Act, guarantees workers the right to vote on questions of union representation by secret ballot. Can you discuss why secret ballot elections are more reliable gauges of employee free choice when compared to card check organizing campaigns?
Well, I think that experience has shown that secret ballot elections and the secrecy associated with everybody's vote is really a cornerstone of the National Labor Relations Act. And we live in a democratic society. And you don't have to take my opinion, because the Supreme Court in two different cases, one that was decided in 1969 and one that was decided in 1974, both concluded that secret ballot elections were the preferred method of evaluating employee sentiments regarding union representation. Conversely, the Supreme Court in both of those cases indicated that authorization cards or signed cards or petition are admittedly inferior to secret ballot elections. And you mentioned the USMCA, and I mentioned that in my opening statement. I think that it's surprising to me that the agency that Congress has charged with conducting secret ballot elections would then move in a direction of making secret ballot elections occur only in a very small number of cases.
Right. Well, thank you. Mr. Salome, in the 117th Congress, then President of the AFL-CIO, Richard Trumka, testified to this committee that unions need employees' private personal information so unions can confront them, quote, at home or, quote, at the grocery store. House Democrats' PRO Act would require that unions are given this information, including home address, cell phone number, personal email address, and more. Do you think workers want to be confronted by union organizers at home or in public at the grocery store?
Thank you for the question, Congressman. My answer is no. I don't think employees want to be confronted at home or at the grocery store, especially the employees that I represent that simply want to refrain from unionization. Now, it's important to note that this kind of information that's given out by the NLRB when it comes to cell phones, email addresses, there's no limitation on the use. So it can be used by unions, third parties who are strangers to the workplace for any reason. As we know, over the past few years, there's been multiple examples of people's personal information being misused. Right. Placing this out there increase that risk.
Well, data privacy is an important subject in this country right now, and it's a bipartisan issue. Is it pro worker to force them to be subject to this against their will, or would they value the ability to choose what information is shared with the union, which my bill, the Employee Rights Act, allows?
That would enhance employee free choice, allowing employees the opportunity to opt out. Obviously, the purpose of the National Labor Relations Act is employee free choice. Sharing your personal information with a union that you may not want harms it, so yes.
And as you know, my home state of Georgia is a right-to-work state. This seems to be very common sense labor law to me, as it allows Georgians to provide for their families without being forced to pay union membership dues as a condition of their employment. Yet the Democrats' PRO Act would supersede right-to-work laws in 27 states in order to force Americans into paying union dues. Unions often claim they need to be able to force workers to pay union dues in exchange for their representation. Can you explain the flaws in this argument?
The flaw in that argument is that it's not a free rider, it's a forced rider problem. So the employees that I represent are represented by unions that they don't want and may have never asked for. So instead of being taken on a free ride, they're taken on a forced ride. Now, as we've discussed today earlier in our written testimony, if they want to get rid of the union, it's very hard because of the NLRB's various blocks and bars, most of which are non-statutory.
Okay. Mr. Chairman, I yield back.